History sheets have become the focal point in the Supreme Court during the hearing on Aam Aadmi Party MLA Amanatullah Khan's case. In a significant development, the Supreme Court has issued directives to address concerns regarding the disclosure of information contained within the history sheets by police authorities. It all started with the case of Aam Aadmi Party MLA Amanatullah Khan, whose minor son's identities were reportedly revealed in the history sheet by the Delhi police. The Supreme Court then emphasized that if any police officer intentionally discloses such sensitive information, it is a violation of the established rules and appropriate action must be taken against them. Now, the court also stressed on the confidential nature of the history sheets, emphasizing that they are internal documents of police organizations and they should not be made public. Now, this case prompted the Supreme Court to also expand its scope, urging all the state governments across India to elucidate their policies concerning history sheets for alleged criminals. Ramik, give us more details as to what exactly has happened here. On one hand, of course, we'll also be talking about Amanatullah Khan, but the Supreme Court, in a broader context, has given a very sharp response and an observation as far as history sheets are concerned. Give us more details on that.
Absolutely, the Supreme Court has to say that the history sheets cannot include details of minor children in absence of evidence against them. Suppose if there is a minor children and if there is no evidence against him, his name cannot come in the history sheet. So such observation has been made by the Supreme Court today. And on the other hand, there is a great relief for the Aam Aadmi Party MLA Amanatullah Khan. The Supreme Court was deciding a plea filed by the Khan against the action of Delhi police, declaring him a bad character and had by opening a history sheet against him. Now, the Supreme Court on Tuesday had modified the decision of the Delhi High Court to the extent that Khan's minor son, who was a school-going children, and his wife, against whom there was no adverse material, wouldn't be included in the history sheet. So the Supreme Court has modified that order to that extent and has further stated that minor children names cannot come into the history sheet until and unless there is cogent evidence against them. When there is no evidence, absolute no evidence, minor children name cannot be included in the history sheet. So this is what has been stated by the Supreme Court. The Supreme Court in the case stated that the amended standing order emphatically says that no detail of any minor relative, son, daughter, sibling shall be recorded anywhere in the history sheet unless there is evidence that such minor has or earlier had afforded shelter to the offender, stated the Supreme Court. The Supreme Court also stated that extra care and extra precaution should be observed by the police officers while ensuring that the identity of a minor child is not disclosed.